federal appeals court has ruled that only the U.S. government can sue under a landmark civil rights law bearing racial discrimination in voting. It's a decision that could significantly change the use of the Voting Rights Act.
So the ruling could set up the next voting rights battle at the U.S. Supreme Court. ABC's Reena Roy has the story.
A major decision out of a U.S. appeals court that could have major implications for voters and elections across the country next year. A federal appellate panel narrowly ruling Monday 2-1 that a key provision in the 1965 Voting Rights Act does not allow people outside the U.S. Attorney General to sue over alleged electoral discrimination based on race.
That would ban civil rights groups like the NAACP and ordinary private citizen plaintiffs from bringing lawsuits under this crucial provision of the Voting Rights Act, dramatically curtailing the reach of one of the nation's most powerful civil rights laws.
This all unfolding in Arkansas, where a local NAACP chapter brought a lawsuit under the act to block a redistricting plan, arguing that it would result in black voters across the state being significantly underrepresented in the state legislature. But the court threw out this case. Sherilyn Eiffel, former president and director counsel of the NAACP Legal Defense Fund, condemning the decision on MSNBC.
This is a judge taking the line from one justice and deciding to upend the crown jewel statute of the civil rights era.
Back in June, in a similar case, the Supreme Court ruled that Alabama's redrawn congressional maps were unconstitutional because they dilute the influence of the state's black voters. That case also originally brought by civil rights groups who won. And this ruling out of Arkansas is expected to be appealed to the U.S. Supreme Court, where it will likely be heard in 2024 during the high-stakes presidential election year. Reena Roy, ABC News, New York.